According to Mr. Kilukumi, the court should not take away what has been laid down by case law. As observed by Mumbi Ngugi J in ACEC Criminal Revision number 13 of 2019, she said, "We are in a familiar yet uncharted territory. When it comes to corruption and anti-corruption prosecutions, we are familiar with corruption because, as this court observes in the case of London Kulal and Lumayete, it wreaks havoc in our society and economy and on the rights and needs of the citizens." She also observed in the above case, that is Criminal Revision number 13 of 2019, that however, it would not be surprising if, for instance, a person charged with committing a particularly heinous or vicious murder or of a particular egregious theft of public resources was denied bail or bond on the basis that fostering public confidence in the administration of justice was a compelling enough reason to deny bail. Further, while the court did not categorize the accused in groups or term the basis of the categorization as a subject matter, there is an underlying thread that the higher the amount of funds that a person is charged with misappropriating, the more severe the bail or bond terms ought to be. I believe that there is a reasonable rationale for this, which emerges from consideration of the grant of bail in other offenses. While both a person charged with affray or simple assault and a person charged with murder have a constitutional right to bail, no one would argue that the same bond terms should apply. Having observed what the Honorable Mumbi Ngugi J said, I now move to the particular charges in order to help me on how to categorize the amount of bail, having considered submissions from both sides. I proceed as follows. In ACC 18 and 19 of 2019, that is count 2 involves accused 1, David Kipchumba Kimosop, accused 2, William Kipkemoi Maina, and accused William Kipkemoi Maina and Paul Kipkoech Serem. The amount of loss was in excess of 93,075714.96 euros. These accused are admitted to a bond of Kenya shillings 50 million with one surety of similar amount, or to a cash bail of Kenya shillings 12 million each. Accused 4 to accused 16, who are charged with abuse of office and failure to comply with various sections of ASECA, are to be admitted to a bond of 5 million with one surety of similar amount, alternatively a cash bail of Kenya shillings 2 million. Accused 17, Geoffrey Mwangi Wahungu, accused 18, Walinya Ongare, accused 19, Boniface Mamboleo Lengisho, to be admitted to a bond of Kenya shillings 2 million with one surety of similar amount, or alternatively a cash bail of Kenya shillings 750,000. In ACC 20 and 21 of 2019, the court moves as follows. Accused 1, Henry Kiplagat Rotich, and accused 2, Kamau Thugge, each to be released on a bond of Kenya shillings 50 million with one surety of similar amount, or a cash bail of Kenya shillings 15 million. Accused 5, Kennedy Nyakundi Nyachiro, accused 6, Jackson Njau Kinyanjui, David Kipchumba Kimosop, to be released on a bond of Kenya shillings 30 million with one surety of similar amount, or alternatively a cash bail of Kenya shillings 6 million. Where I have included some of the accused who have not taken plea, their release order will be signed and approved on the satisfaction from the IO that they have reported to the DCI and have been processed. All accused to deposit their passports and all their traveling documents in court As argued, if they left their passports behind, they are accorded 48 hours to surrender the same. Otherwise, if they meet conditions of release, they will be released forthwith. The places of work of accused persons are considered scenes of crime, and they should keep away. If there is any need to visit their places of work, that should be done in the company of the IO. All accused should not approach any witness in any manner for whatever reason. Such actions will lead to cancellation of bond. Each accused is required not to destroy any evidence in whatever form. If adequately brought to the attention of the court, such bond terms will be revoked, and such accused will be denied bail till the determination of the case. I should not have said this, but let me say it. No counsel should come to court without proper instructions. In relation to Mr. Anani, you make sure you come with sufficient instructions so that you proceed. Both prosecution and defense counsels to exchange email addresses by each appointing a key person of contact. The DPP/DCI to supply all statements and documentary evidence within the next 14 days. Pretrial compliance to take place on 8th July 2019. That will just be compliance. After that, we'll set a date for the pretrial conference. 8th of August, yes, sorry. Thanks for that. So all accused not present today and who have not taken plea to organize themselves to appear before the DCI, latest 26 July 2019 at 2 p.m. In default, DCI is at liberty to pick warrants of arrest. For those who have not taken plea, the plea is slated for the 29th of July 2019. Those who took plea are at liberty to stay away. So compliance is on the 8th of July 2019. No, okay, 8th of August 2019. That is the ruling for today.